Yes, my name is James Clark. I'm an injured worker out of the state of Idaho who handled this case for the first 2 years on his own and not because he wanted to. But then I guess what the Industrial Commission did is they assigned an attorney to my case for me, and that person happened to be Lynn, LUKER, Idaho state legislator, who sits on the Judicial Committee. And based upon the fraud and everything that I caught the state fund doing prior to him being, I guess, assigned to my case, what's happening here now where I'm at, because I did kind of lost in the Supreme Court, I guess, but maybe I didn't in some ways, because they did affirm that the state fund did commit fraud or based their information on fraudulent documents. And then in the Industrial Commission's findings of facts, they did state that the state insurance fund did receive records that did not pertain to the injury. So again, if I was to put those two together as the state fund is putting, because I assumed that I lost because they affirmed the commissions. I guess, well, that's what they did, but then they did state that they affirmed on two different areas in regards to me, so I'm about ready to file on that. But I did receive a filing from the Industrial Commission on, it was filed for October 18th of 2003, and what it is, it's an order, and I believe it's a request for an order to stop me from filing any more proof to the Industrial Commission of the abuse of authority by Mr. Donahue, who was my referee, and then he was still my referee during my hearing, which clearly he should have stepped down. But this is what they've done to me. This is what they're stating, that I am I'll spell the word when I get to it. The Idaho Industrial Commission has broad jurisdiction under workers' compensation laws. Idaho Code 72707, unless otherwise provide, the Commission has general and exclusive jurisdiction over all questions arising under workers' compensation law. Idaho Code 72101. The Commission acts as a judicial or quasi-judicial body when conducting cases brought before it. The Commission has the authority to promulgate and adopt reasonable rules and regulations for effecting the purpose of Idaho workers' compensation law. They shouldn't be able to do that, because what they do is they do it for their favor, as well as for those involving judicial matters. Idaho IC 72508. The Commission is not required to comply with the provision of the Idaho Administrative Procedure Act, IC 675201. When the provision of the Idaho Administrative Procedure, adopting rules, my apology. The Commission is not required to comply with the provision of the Idaho Administrative Rule Act, 675201, when adopting rules and regulations involving the Commission's judicial function. In conducting hearings, the Commission has broad authority to require parties to behave appropriately and to avoid conduct which obstructs Commission's proceedings. Well, isn't that what the Idaho State Insurance Fund did through their attorneys on August 1st, 7th, and the 11th of 2008? CIC 72715. Further, by signing a pleading or other paper filed with the Commission, a party affirms that there are significant grounds to support the position asserted therein, and that is not submitted for delay or any other proper purpose. See Rule 3E, Judicial Rules of Practice and Procedure under the Idaho Workers' Compensation Law. The Commission is empowered to impose appropriate sanctions for any violations of abuse of its rules or procedure. The Commission has no specific procedure in place to constrain VEXATIOUS litigants. That's what they're calling me. The ex litigant. However, from the foregoing, it is clear that the Commission has the inherent power to do so. Yeah, because they make up their own rules. The Commission is cognizant of the fact that free access to the Commission by injured worker is an important right which would be compromised only under egregious circumstances. Now, but you see, I received a letter back in September 2012 from Mindy Montgomery, Director of the Industrial Commission, stating if I enter any building that they occupy, I could be arrested. So, again, I'm being violated, obviously, my due process by not allowing me to enter this building to ask questions and receive my documents that clearly they're going to get rid of because they're not allowing me to come and pick them up, or I'll be arrested. And I have that document. Matter of fact, I have two of them. I have one for September 2012 and another one in September of 2013. We believe that Rule 59 we believe that Rule 59 of the Idaho Court Administrative Rule, ICAR, provides that appropriate balance between free access to the courts and the court's need to manage its docket. In this matter, we deem it appropriate to rely on Rule 59 ICAR as a model for evaluating and treating the whatever that word is, litigant in proceedings before the Idaho Industrial Commission. Rule 59 of the Idaho Court Administrative Rules. The Idaho Supreme Court has adopted the Idaho Court Administrative Rule, ICAR, which are for the purpose of administering and supervising the unified and integrated Idaho judicial system by the Idaho Supreme Court. See Introduction, ICAR, in particular, Rule 59 ICAR governs the so-called procedural litigant. Rule 59 provides a procedure for handling the action of persons who habitually, persistently, and without reasonable grounds engage conduct that delays or hinders the effective administrative of justice. Wait till you hear what I've got to say. Impose an unacceptable burden on the judicial personnel and resources, and impedes the normal and essential functioning of the judicial process, ID period, underline. The procedure in Rule 59 allow a court to address this impediment, IMPEDIMENT, to the proper functioning of the court, while protecting the constitutional rights of all individuals to access to the courts. ID. Again, I've been denied access to the Industrial Commission, which is the courts of the judicial. In particular, Rule 59 states that a judge may enter a pre-filing order prohibiting a judicial litigant from filing any new litigations in the courts of Idaho, pro se. That would be me, in the courts of Idaho, pro se, without first obtaining leave of a judge of the court where the litigation proposed to be filed. A prerequisite whether to such an order is that either a magistrate or a district judge must refer the consideration of whether to enter such an order to the administrative judge, or the person being considered must be a party to an action before the administrative judge. James W. Clark is a party to this action before the commission, which is obviously a court. Therefore, on the basis, the commission addressed the consideration of whether to enter a procedural litigant order. Okay, again, what I'm about to tell you is in their findings. In their findings, right here. Finding. And that finding is on starts off on page 3. Okay? Page 3. Findings. Using Rule 59D, ICAR as guidance, A person may be found to be a vicious litigant based on any one of four findings. First rule, 59D1 states that a person may be declared a vicious litigant in Idaho if that person, in the immediate preceding 7 years prior, a 7-year period, the person has commenced, prosecuted, or maintained pro se at least 3 litigations that have been finally determined, prosecuted, or maintained pro se at least 3 litigations that have been finally determined advisory to that person. A review of files before the Idaho Industrial Commission shows that Mr. Clark, in the immediate preceding 7-year period, has commenced, prosecuted, or maintained pro se at least 3 litigations that have been finally determined advisory to him. Now, under here, litigation means any civil action or proceeding, and including any appeal from an administrative agency, any appeal from the small claims department of the magistrate division, small claims. Well, that better not be what they did. Any appeal from the magistrate division to the district court, and any appeal to the Supreme Court. Now, because of what Miss O'Barr was just telling me recently that I caught and found in my paperwork, something was filed, and I wonder if that's what they're trying to say there. But it's what's about ready to come is what. Okay, so here we are on page 4. Page 4. The Commission recognized that in the present case, Mr. Clark was both awarded some benefits and denied others in its May 2nd, 2012 decision. The Commission acknowledged that the language from Rule 59D1 ICAR requiring that a matter be fully determined advisory to the litigant might not be satisfied because Mr. Clark was awarded some of the relief he requested. Well, where's my attorney? It might be said that Mr. Clark's May 2nd, 2012 decision was one that was obviously determined to him. However, wait a minute, what are they trying to say here? Requiring that a matter be finally determined advisory to the litigant might not be satisfied because Mr. Clark was awarded some of the relief he requested. Nevertheless, Mr. Clark did appeal the Commission's decision to the Idaho Supreme Court. In that way, it might be said that the Commission's May 2nd, 2012 decision was one that was advisory determined to him. No, it wasn't. However, we declined to use this as the basis for any action. Why, sure in the hell hope so, because that's another lie. That's because they got things that are posted that are false. Like, I fired an attorney, Roger Brown, and it's posted, and I got a document from that law firm really stating why Roger Brown removed himself, because he went to another firm. And then, Mr. Lynn LUKER, weren't you vice president of the Get Your Law office at one time? And isn't that the law firm that the Industrial Commission is mentioning in their findings of facts and conclusions of law on May 2nd of 2012? I just found that out recently, Mr. Lynn LUKER. Vice President. Must mean you were one of the ones that opened it up or something, wasn't it? You get your law office, to get your law office in Idaho, Boise. Mr. Lynn LUKER, who is now a legislator and an attorney who takes workers' comps and destroys them. Second rule, 59D2, states that a person may be declared a vicious litigant in Idaho if, after a litigation has been finalized, attempted to litigate. Okay. Second rule states that the person may be declared a judicial litigant in Idaho if, after a litigation has been finally determined against the person has repeatedly relitigated or attempted to relegate pro se either A, the validity of the determination against the same defendant or defendants, the state insurance fund and their attorney, as to whom the litigation was finally determined, which was them, or B, the case of action, claim, controversy, or any of the issues of fact or law determined, because fact of law, well, in your findings of fact and law that you did on May 2nd of 2012, you stated that I fired an attorney. Bring before me the facts of that, Mr. Donahue, and the commission as a whole. The same defendant or defendants as to whom the litigation was finally determined, or B, the cause of action, claim, controversy, or any of the issues of fact or law determined or concluded by the final determination against the same defendants or defendants as to whom the litigation was finally determined. Mr. Clark has since that time that the Idaho Supreme Court fully and finally disposed of the issue in this case. Disposed. I hope they didn't throw away my paperwork, because we ain't done yet. Filed numerous documents with the commission raising the same issues. Okay, was it the commission I was filing these documents to, or the Supreme Court, guys? Come on now. Finally disposed of the same issues in this case. Filed numerous documents with the commission raising the same issues of facts and laws as we raised and decided on appeal, as were raised and decided on appeal. Third rule, 59D3, states that the person may be declared a judicial litigant in Idaho if that person, in any litigation while acting pro se, repeatedly files unmeritorious motions, pleadings, or other papers, conduct unnecessary discovery, or engage in other tactics that are frivolous or solely intended to cause unnecessary delay. A review of the files herein shows that Mr. Clark has while acting pro se, repeatedly filed unmeritorious motions, pleadings, and other papers, including at least 4 requests for emergency hearing, all filed on the same day, and matters already decided by the Supreme Court. Now, we're back here over on number 4. The commission. The rule 59D3 states that a person may be declared. I mean, you attack me, guys. I want you, the commission, that you're trying to call me this person that has repeatedly files unmeritorious motions, pleadings, or other papers, conduct unnecessary discovery, or engage in other tactics that are frivolous or solely intended to cause unnecessary delay. Down here, you can see where they have Clark versus Oneida County. I challenge anyone. Let me try to get this thing real still for you. There. There it is. Clark versus Oneida County. IC number. I will pay anyone my whole Social Security check of $707, because that's all I get. If you can show me where I am connected to that case. Yeah. Okay? My whole Social Security check. Because, again, it's truly the Industrial Commission who are filing these frivolous charges to help cover up the abuse of Mr. Donahue, referee, and to help cover up their false statements They're in their findings of facts and conclusions of law, because when they put in there that I fired an attorney, Roger Brown, it was only for the sole purpose to help Mr. Lynn LUKER's lien that he had filed fraudulently. He's saying that he filed on December 27th in relation to my case that he walked out on. And you're running for re-election. I'm going to come and help you run for re-election, Lynn LUKER, because I want these questions answered. I have every right to, and I'm not coming to town as a threat to anyone. Do I not have a right? I believe I do. I believe I'm a U.S. citizen, and I do believe I live in the United States of America, but I'm starting to wonder nowadays, because I have a right to ask you these questions. Just like that hearing that we had on that phone the other day. Obviously, you all already had it planned out. I had 7 minutes for oral argument. I didn't want oral argument over the phone. Good thing I recorded that one, huh? Because again, it will clearly show how I'm being violated, how I'm being abused and taken advantage of, Mr. Lynn LUKER. Because your statements and your stuff is a lie. And some of these filings that you got in here that are marked on dates that shouldn't be marked. Because when I came and picked up those records, as Miss Dina Burke stated, on the 22nd or the 21st, it was done. It was over. So for you to start writing these things that happened after that date clearly shows, again, you ain't nothing but a scammer. Just because you sit up there on the judicial seat and the committee as vice chair, and when you're appointed to people's workers' comp, you screw them? Well, you know what? I have every right. And you want to show these videos, and you say you called the cops, Mr. Lynn LUKER, and you made a report? Oh, you know what? I'm going to seek damages for your false writings. Because in your writings, you literally said that I threatened you. Mr. Lynn LUKER, Idaho legislator, I want you to come forward and show me that I threatened you. Because obviously, I'm not in jail, am I? Do the cops kind of go back and forth through my house now because of the other day, because all the cops were here? Because I was negotiating things with Miss Racheal again, who I also associated with during my appeal, which, there was no communication because I'll read you what I had filed just recently. Oh, in regards to this. So again, who's really doing the frivolous filings, Mr. The commission as a whole, because it is the commission as a whole that, that did this, see, the commission as a whole, all three of y'all fat-ass boys signed the thing, and y'all wonder why I'm angry. I have every right to be angry. The commission recognizes that the present case, Mr. Clark was both awarded some benefits and denied others in its May 2nd, 2012 decision. The Commission acknowledged that the language from Rule 59D1 ICRA requiring that a matter be finally determined advisorily to the litigant oh, wait a minute. Oh, all right. Okay, here we go. Including the last 4 requests for emergency hearing. And the reason why they were done, again, because Miss Racheal kind of reminded me when I was talking to her, she had received it, told me that I had put the wrong date on there, so I had to correct it. So it's just a correction. But they're making it out like, yeah, I did file an emergency hearing. Because the Supreme Court based their opinion and their remediature on fraudulent documents and then stated that I didn't even discuss the medical records on my CD that I have of the Supreme Court oral argument clearly shows that I showed up all 3 of them. So I don't know what they've got in their record or on their CD right now. Okay. The review of the files herein also shows that Mr. Clark's engaged in tactics that are frivolous. Really? Is this what you call not frivolous? Because that's a false statement right there in writing. Attacking me. Again, I am seeking damages, and I will seek damages. Unless y'all put a bullet in me before I can get there. Oh, is that what y'all mean by, is that why the cops come? Well, yeah, but because you see, I ain't threatening myself. I ain't threatening no harm to myself. I have fear that if I come forward, I can have a bullet put in me. A review of the following herein as shows that Mr. Clark has engaged in tactics that are frivolous, including telephoning commission staff and repeatedly requesting legal advice. I'm not asking for legal advice. I want to know what the hell is in the records that I'm being denied. Because I was denied, because I have documents of it. Review of the filings of the actual documents that were filed to the Supreme Court by the Industrial Commission. Not the ones that they sent to me. The ones that they actually filed. Because the Supreme Court, Steve Kenyon, clerk of the court, denied me that access. The commission also, before, during my argument of their findings of facts. Because that's what I appealed. So I don't know how they all of a sudden got all my medical and everything in there. I was appealing their findings of facts. That wasn't true. A review on the files herein also shows that Mr. Clark has engaged in tactics that are frivolous, including telephone commission staff and repeatedly requesting legal advice of the commission staff on matters previously adjudicated, not that I'm aware of, making repeated record requests for the same documents, submitted papers requesting that the commission staff file these documents with the U.S. Supreme Court. No, not the U.S. Supreme Court. I wanted my, oh, you motherfuckers, and the Ninth Circuit Court of Appeals, and engaging in continuous and disruptive behaviors over the telephone with commission staff. Well, how come Mr. James, what the hell is that first guy's name? Well, Mr. James won't contact me either. So why is that? Isn't he the whatever he is, the Attorney General? So, of these frivolous actions, and unmeritorious filing, and a burden on the commission staff, impede the commission's normal functions. What about my normal functions? Why am I allowed to be doing it? The commission finds that this is a basis. The commission finds, again, with a false statement that I supposedly did this case on my own. And you know what that relates to? Something back way years back in the 1920s in regards to some Indian land. Yeah, look it up. And I can't get no attorney to step forward in a civil action for me because I do want to file civil actions. I want to file a civil lawsuit on the state of Idaho and the state insurance fund, Miss Jewel Owens, for her fraud committed on August 1st, 7th, and the 11th of 2008. And I also want to civilly sue, the firm of Anderson, Julian Hall because of their lawyer, Miss Racheal O'Barr, statements that, and continue to harass me when I'm asking her questions because I have been also denied by Miss Racheal O'Barr, videoed. She knows it. She was aware of it before she even before I even got to that question, that I wanted a review of the policy of the state insurance fund in regards to my accident. But she said no. Below, the commission finds that there is basis to conclude that James Clark is a vexatious litigant. That's a tack on who I am as a person and who I was prior to my accident of 2008. Litigant, and that a pre-filing order should be issued following the guidelines in Rule 59E. You see, they got all the E's, A's, A1, AE. Well, you know what? I don't know it all, but if you read it in the writings, it's there for me because I'm not no attorney. And this is where I think laws need to be changed because I noticed that a lot of rules took effect in September of 2013 in regards to workers' compensation. It wouldn't be because of me, because I don't think you guys have ever seen somebody like me before. Because I am me. Proposed pre-filing order. James W. Clark is hereby declared to be a... See now, if this is an order that was already done, this is the first time I've ever heard of it. And I didn't even get to argue it. If in fact, this is how it, now they're going to read it, because it is a little confusing for me here. James W. Clark, proposed pre-filing order. James W. Clark is hereby declared to be a particular litigant pursuant to the standards set forth in Rule 59 ICAR and as applied by the commissions herein. This declaration is based upon the findings set forth above. That means on page 4, down at the bottom. And as applied by the commission herein. The declaration is based upon the findings set forth above. James W. Clark is precluded from filing any further litigations, motions, pleadings, or other paper before the commission pro se without first obtaining leave of the commission. Because see, I'm thinking that's who I've been filing to is the commission. Why, is there another part of the commission inside this commission that I don't know about? This declaration is based upon the findings set forth above. James W. Clark precluded from filing any further litigation, motion, pleadings, or other paper before the commission pro se without first obtaining leave of the commission. All requests for leave to file with the commission shall be submitted in writing. No further electronic or telephone communication will be permitted. Again, am I being denied access to the courts? Because if I file something, I'm going to be denied it because of the fraud that was committed and who all is involved, especially Lynn, LUKER, and Idaho's legislator. No further electronic or telephone communication will be permitted. Disobedience of this pre-filing order shall be grounded for appropriate sanctions. Well, why didn't y'all sanction Miss Jewel Owens and the state insurance fund for the fraud instead of sanctioning me $300, which was paid for not signing those medical releases when I still had time based upon timely time, just like they did when you were forcing me, Mr. Donahue, to sign those medical releases? Because in your writings, again, that's how it stated when I ended up receiving those 3 binders that Mr. Lynn LUKER had in his possession that he's saying that he did all this work on. Isn't that right, Mr. Lynn LUKER? Didn't I have those documents, those folders, or those binders for almost 8 months before you were hired or you were assigned to my case to get those records back, probably? Mr. Clark shall have, well, this is where I'm at here. I'm a little confused. A pre-filing order shall be grounds for appropriate sanction. Notice, Mr. Clark shall have 14 days to file a written response to the proposed order, but I'm being told I'm not allowed to file anything. Mr. Clark shall have 14 days to file a written response to the proposed order and the findings set forth above. If Mr. Clark desires to file a written response to this proposed order and findings, he may file the written response by mailing a hard copy to the Idaho Industrial Commission, P.O. Box, which is the same people that I've been doing it to. Same people. If a written response is timely filed, the Commission shall determine if a hearing is necessary. If not, if no timely response is filed, the proposed pre-filing order will be issued by the Commission. It is so ordered. Now, dated October 18th of 2013, which is all done by all 3 of the commissions. Okay? Now, where we're at here is by the way it sounds to me, what they're trying to pull here is, this has already been done, but they're still going to pretend like they're going to give me time to respond, but they're going to say that I did it. I didn't do it in a timely manner. Well, I'd already faxed them because, again, I'm not going to be denied access to the court, and the Commission is considered a court in the way that I've been told. So, and today, I faxed a copy of that. Well, I faxed them a copy of it yesterday, but I didn't send a certificate of mailing with it. So what I did, so everyone knows, is I filed another certificate of filing and I faxed it to them. And this is what I'm sending to them. This is my response to them that I'm sending out in the mail today. It is. This is what I'm mailing to them. This is my response. This is my response to the commission. Okay, this is what it looks like, because I got a document just now from my job that clearly shows that the notary has been altered. So okay, there it is, properly notarized. All right, and there is no second one that sets off over here on the side over here, off over here that says also Oregon. And then the notary of the person that did it over at my bank, his name ain't even there anymore. It's just some, yeah. It's so okay. This is what I wrote to him. You better listen, Mr. Donahue, and the commission as a whole. The Industrial Commission as a whole. This is James W. Clark, appellant/claimant versus Crybaby Food LLC, Idaho State Insurance Fund. Commission number 2008-013505, appellant/claimant's response to administrative order filed October 18th of 2013. The Industrial Commission as a whole. Thomas B. Baskin, Chairman, and R.D. Maynard, Commissioner. Thomas E. Limbar, Commissioner of the Industrial Commission. This injured worker takes your statement as an insult to my near death and the loss of my arm through no fault of mine. For you all to call me a fictitious person/litigant is a straight-out lie, an attack on my character and who I was as a person before my injury of April 17th of 2008. On April 17th of 2008, on the job site of Crybaby Foods, an onion processing plant in Weiser, Idaho, James W. Clark fought for his life for 10 minutes while another employee tried to find a way to shut the machine off while the machine was trying to pull him into it. But in your writings, you make it sound like his arm was only stuck or jammed in the machine. There is a significant difference between jammed and stuck compared to fighting for your life for 10 minutes till the machine was shut off. That's only common sense. If an insurance fund enters into a contract for $150 for transportation, and it was a contract signed, transportation with your 86-year-old mother on January 27th of 2009 for surgical procedure, and Linda Elwood for aftercare by Dr. Hansen, for this was a contract, and that contract was performed twice, that the hospital requested to be set up and be put in place before surgery would take place. And that surgery did happen due to Dorothy Bowman's transportation on 2 occasions. May she be your real or stepmother, and to have a state fund insurance company who tries to take advantage of her by not paying, anyone reading this would come to a conclusion that you as a real or stepson must step in. It is common sense. But you all, the Industrial Commission as a whole, Thomas B. Baskin, Chairman, and R.D. Maynard, Commissioner, and Thomas E. Limbaugh, or however you pronounce it, Commissioner of the Industrial Commission, want to call me a fictitious person/litigant is a straight-out lie and an attack on my character and who I was as a person before my injury of April 17th of 2009. If in fact, based on the February 4th, 2009 letter from Mr. Hall of the firm Anderson, Julian Hall, LLP, representing the state fund, that was mailed to my mother's home address, that they had paid that bill of aftercare and the transportation, and they expected for me to be at the next surgery that was set for later that month due to the first being postponed till after arriving, and the IVs are in me. Then the state fund had a clear duty to contact Miss Bowman and Miss Elwood that their service was no longer needed, based on the February 4th letter, and claimant appellant's response to their February 4th letter of 2009 that the state fund should contact someone other than Miss Bowman for transportation to my surgery to be performed on my injury of April 17th of 2008, which was paid under different coverage than my medical, that the state fund and my attorney, Lynn LUKER, /legislator for the state of Idaho, tried to add in it as part of the appeal, and you as the commission as a whole, that you stated I had filed unwarranted files. That's absurd. Rule 6, ex parte communication. Ex parte communication prohibits from the time an appeal is filed until it becomes final under Idaho Code 721368. No person involved in the appeal shall communicate, either directly or indirectly, or shall discuss with the commission or a referee the merit of any matter in which an appeal is pending, unless all parties and claimants / appellants and all parties are there and their attorneys are present. Clearly, on several occasions during my appeal, the state fund, through Racheal with the firm Anderson, Julian Hall, LLP, representing the state fund, called and emailed and wrote letters to the claimant / appellant in a matter wanting to let the appellant know that the appellant was wanting to make a settlement offer. I would have to also add in the $27,000 and other overpayment that the state fund had no obligation to pay based upon Dr. Hansen's impairment rating that had already been paid to the injured worker before the November 18th, 2010 hearing, before the commission, and before Lynn LUKER was hired. The commission, this did occur during the appeal before the Supreme Court, May 2nd of 2012, wait a minute, that had already been paid to the injured worker before the November 18th, 2010 hearing, before the commission. This did occur during the appeal before the Supreme Court, May 2nd, 2012, through, as the appellant understood, to my naive and lack of law, through this letter and your false statements about my filings, amount to the same that has been already considered at the Supreme Court. The commission as a whole, Thomas B. Baskin, Chairman, and R.D. Maynard, Commissioner, and Thomas E. Lembar, Commissioner of the Industrial Commission, want to call me a fictitious person / litigant is a straight-out lie, an attack on my character. The commission's findings and their findings of facts and conclusions of law and order of May 2nd of 2012 stated and posted on their webpage, and their decision that the appellant had fired an attorney, Roger Brown. I, the injured worker, is asking and demanding that the commission bring forth their findings of facts that I fired this attorney, for this is a findings of facts that is posted. That is, again, an attack on my character of who I was as a person before my April 17, 2008 injury, and a damage to my reputation. Also in the order of October 18th of 2013 that I, James Clark, is filing upon, the commission as a whole, Thomas B. Baskin, Chairman, and R.D. Maynard, Commissioner, and Thomas E. Lembar, Commissioner of the Industrial Commission, want to call me a fictitious person litigant. Again, the commission as a whole, Thomas B. Baskin, and Lembar, Commissioner of the whole, the Industrial Commission, want everyone to believe that I'm a fictitious person / litigant. In your findings, but you all are stating on page 4 of this order that this injured worker, who has been clearly taken advantage of, have been a pro se on Clark versus Oneida, that's spelled O-N-E-I-D-A, County, IC number 2002-503-220, filed January 23rd, 2007, and dismissal filed November 15th, 2007. I, the injured worker, is asking that the commission bring forth this injured worker, their finding of May 2nd of 2012, and their finding of the above case that is being used to consider this injured worker to be a fictitious person. This is another lie in the commission's findings to help cover up the abuse of Douglas Donahue, referee, assigned to the case number 2008-013505. Due to the overwhelming mistakes that this commission has made and has been damaging to my appeal before the Supreme Court and stated in their findings of facts in this worker comp's case, this injured worker is asking that the commission forward my case to the district court for damages for the clear mistakes that this commission has made during the commission's handling of this case, and the clear abuse by the commission and the false statements that are still posted that are straight out lies that this commission, by the records as a whole, cannot defend. Alright, y'all? And of course, right here, that's why I followed again today. So, everybody, so done properly, a certificate of mailage, and this is going out in the mail today because, I faxed each one of them, again, and, I'll be sending a letter over here to the law firm, and again, I have faxed, and I will be mailing a copy to the Industrial Commission, a hard copy. So again, who's really